The Foreign Contribution Regulation Act, enacted in 1976 during the emergency, then amended. Then this law was replaced by a law enacted by the Parliament in 2010. Significant amendments were made to this law in 2020. Significant amendments have been proposed to this law in 2026. The Parliament was supposed to discuss and pass these amendments, but then it could not happen because of the protests. That does not mean these amendments would not be passed. Critics argue that once the state elections are over, particularly to the Legislative Assembly of Kerala and Tamil Nadu, Parliament would again convene, discuss these amendments, and pass these amendments. What is this law? What was the need to enact this law? What were the important amendments to this law in 2020? What are these 2026 proposed amendments? Critics argue that there is a link between the Waqf Amendment Act of 2025 and FCRA amendments of 2026. What is that link? All this and much more we are going to discuss in this video. But first up, who do you think is the most powerful Indian Prime Minister ever? Different people may answer differently, but I think the options would always remain two: either Mr. Modi or Mrs. Indira Gandhi. Critics argue that there is a lot of things which are in common between Mr. Modi and Mrs. Indira Gandhi. For example, today, if there are protests against a government policy or program, these protesters are labeled as anti-national. Similarly, during the 1970s, when Mrs. Gandhi was the Prime Minister, and if there would be protest, immediately the then government would say that there is a foreign hand behind these protests. For example, when there was a call for total revolution, Sampurna Kranti, given by Jayaprakash Narayanan to overthrow the Indira Gandhi's government at the center, the then government immediately said that there is a foreign hand behind these protests. Foreign hand was a euphemism for CIA, the intelligence agency of the United States. Long story short, the then government felt that these protests had been funded by foreign countries, foreign institutions, and these protests are meant to destabilize the democratically elected government of India. And as such, a law was enacted in 1976 known as this Foreign Contribution Regulation Act. What was the purpose? Foreign contribution cannot be received by certain individuals and institutions. For example, if you are a candidate contesting election, if you are an editor or a publisher of a newspaper, or even a cartoonist, or if there are judges or government servants, or if you are a member of any legislature or even political parties, you cannot receive foreign contribution. You cannot receive foreign donation. But if there are other organizations which receive foreign donation, foreign contribution, they have to register and get this FCRA license. Once you have received this FCRA license, only then can you accept and receive foreign contribution. Which means foreign contribution was regulated in India because of this law. Then few years later, NGOs were also brought under the ambit of this law, because the government thought that these NGOs, they're receiving foreign contribution, but using that foreign contribution, they are also fueling protests in India. For example, protests against the nuclear power plants in India. Nuclear power plants are required, are needed. And there are some environmental organizations which are fueling protests against these nuclear power plants, but these protests have been fueled by foreign governments, foreign contributions meant to destabilize the government of India. But then this law was repealed in 2010 and a new law was enacted in 2010. What was the need to repeal this law? Listen to me carefully. There were few problems with this law. For example, if this entity wants foreign contribution, foreign donation, it has to register, get this FCRA license. But once you receive this FCRA license, you are registered, this registration was valid forever. There was no expiry date for this registration. Plus, if this organization, NGO for example, it receives foreign contribution, foreign donation for education, for healthcare, for nutrition, for any other purpose, but then these funds could also be diverted. For example, an organization was given FCRA license so that you can receive foreign donation meant to provide educational opportunities to the weaker sections of the society. But you were using these funds for converting people into, let's say, Christianity. And then in 2010, since the previous law was considered weaker, in 2010, a new law was enacted to make the regime of registration much more effective. How? Time-bound validity. Once you are given the license, once you are registered, you can receive foreign contribution, but this registration would be valid for 5 years. That does not mean you cannot renew this registration. You can renew, but at once it will be valid for 5 years. And if you are receiving money, let's say for educational purposes or health purposes or nutritional purposes, you can spend only 50% for administrative purposes. For example, you receive foreign contribution, but you are spending a chunk of this money as salaries, as rent, as travel, which means less than half of this money which you have received for promoting education or nutrition or health, more than half of that money you are spending for administrative purposes. That's how in 2010, a regulation was enacted to ensure that only 50% of these foreign contributions can be used for administrative purposes, which means rent, which means salaries. The remaining 50% has to be used for the intended purpose for which you have received this foreign contribution. But then in 2020, significant amendments were made. What are these amendments? Listen to me carefully. For example, this is an entity X. It also has an FCRA license. Z, it also has an FCRA license. This X receives, let's suppose, 30 crores as foreign donation. Prior to this amendment, if X has received this foreign contribution, it could have transferred a part of these funds to Z. Why? I received foreign contribution of 30 crores. I am also registered under FCRA. You are also registered under FCRA. But you did not receive any foreign contribution. Since I have received, I could have transferred a part of this foreign contribution to you. But then in 2020, the Parliament enacted the law, amended this law, and because of this amendment said, this transfer cannot happen. If you have received this foreign contribution, only you can utilize these contributions. You cannot transfer these contributions to another entity, even if that entity is eligible to receive foreign contribution. Number two, if you want to apply for FCRA license, for example, you are the director or office bearer of this non-governmental organization, you have to provide Aadhaar as a document for identification. Not only you, any office bearer, any director, or all those who are the key functionaries of this organization, you have to provide Aadhaar as an identification document. I'll tell you later why. Third, FCRA account. Prior to this amendment, if I had to receive foreign contribution, I could have opened a bank account anywhere in this country for receiving these foreign contributions. But then in 2020, the Parliament said no. There will be one bank which will be designated by the central government. Only in that bank's branch, specific branch, you can receive foreign contribution so that we can keep a track of these foreign contributions. And that's how the rules were made. And the rule said that there will be a branch of the State Bank of India, Parliament Street branch, anywhere. If you want to receive foreign contribution, any NGO, any entity, any university, you have to open this FCRA account in the State Bank of India, Parliament Street branch, nowhere else. Previously, I told you that 50% of your donation you could have spent on administrative purposes, for administrative reasons, for salary, rent. In 2020, the Parliament said, no, we are reducing this limit. Now you can spend only 20% of your foreign contribution, foreign donation for administrative purposes, not 50%. Previously, the law said if the license of this particular entity is suspended, it can be suspended for 180 days. But then the law said it can be further suspended for another 180 days. Significant amendments were made in 2020. But most importantly, I told you the license, FCRA license, if you want to receive foreign contribution, is valid for 5 years. Then it can be renewed. The law said within 6 months of the expiry of your license, you have to seek renewal of this FCRA license. And for that, we have a ministry known as Ministry of Home Affairs, which is the nodal agency to deal with all these FCRA matters. But when this law was amended in 2020, the amended law said, wait a minute. If you are renewing your license, the central government may conduct an inquiry. And once that inquiry is over, then we may renew your license. Why do you need to conduct an inquiry? Maybe we will check whether this entity is fictitious, benami, whether this entity has been prosecuted or convicted for creating communal tension. For example, this entity which has received foreign contribution, but it is using this foreign contribution to resort to conversion, religious conversion in different parts of this country. And this is where it was aimed at various Christian missionaries who were allegedly receiving foreign contribution, but then utilizing this foreign contribution not for the intended purpose, but for religious conversion. And we will also conduct an inquiry. If the money that you have received for foreign contribution, as foreign contribution, whether you are diverting it to others, whether you are spending more than 20% or less than 20% for administrative reasons, once we are satisfied after this inquiry, only then we can renew your license. Otherwise, your license will not be renewed, which means you cannot receive foreign contribution. And that is how a large number of organizations, Greenpeace and various other organizations, their FCRA licenses were cancelled. Even some universities, their FCRA licenses were cancelled. And some people thought that these NGOs, they are primarily dependent upon foreign contribution for their purpose. And if you are strangleholding all these foreign organizations, these non-governmental organizations, then they won't be able to function. Matter went to the court. Noel Harper v. Union of India 2022. These 2020 amendments were challenged before the court, and a 3-judge bench of the Supreme Court gave its verdict. This bench was headed by Justice Khanwilkar, who is right now the Lokpal of India. The Supreme Court said that you have a fundamental right to establish an association, an organization, a union. That's a fundamental right under Article 19 of the Constitution. You have a fundamental right as a citizen to create an organization, to establish an organization, to form a union, association, or a cooperative society. But that does not mean that includes the fundamental right to receive foreign contribution. So creating an organization is your fundamental right. But then to say that since I've created this organization, I also have a fundamental right to receive foreign contribution for this organization, these don't add up. These receiving of foreign contribution is a privilege and is subjected to regulatory conditions, which means the state may regulate who is eligible to receive this foreign contribution, for what purpose, and regulate whether there was diversion of these foreign contributions or not. Second, the Supreme Court said these foreign contributions, they have a material impact on the socio-economic structure and polity. So if we cannot completely do away with foreign contribution, but we have to have a minimum threshold, minimum level of these foreign contributions. Otherwise, our sovereignty will be affected. Because you might see, if the foreign contribution to entities in India is unregulated and there is no limit, then in that case, what will happen? In that case, there may be organizations receiving foreign contribution in India, and they might destabilize elected governments in India. They might launch protests against power plants in India at the behest of foreign governments or vested interests. Supreme Court was asked, my lord, why is there a limit of 20%, that up to 20% of the foreign contribution you can spend on administrative reasons? Why can't we transfer a part of our foreign contribution to another entity which is also eligible to receive foreign contribution? It becomes very difficult for NGOs in different parts of the country to come to Delhi, open a bank account with the State Bank of India at the Parliament Street to receive foreign contribution. It makes it very difficult for NGOs. The Supreme Court said no, all these are reasonable restrictions because they serve legitimate national interest. These amendments of 2020, long story short, these are not violative of Articles 14, 19, 21. They are not arbitrary. They don't violate your freedom. They are not violative of the due process of law under Article 21. But now in 2026, when we are talking about these amendments which have been proposed to FCRA, we need to go back in time and look at the order of the Delhi High Court of 2014. What is that? This is a significant order. I told you at the start that there are some entities which are not eligible to receive foreign contribution. Judges, cartoonists, editors, publishers, political parties as well. So political parties are not allowed to receive foreign contribution. This is settled in the law. But then there was an allegation that there are two political parties, two principal political parties, the BJP and the Congress. They have received foreign contribution from a London-based entity, Vedanta. Since you have received this money, foreign contribution, to political parties, this is violation of FCRA. Matter went to the Delhi High Court. Delhi High Court directed the central government and the Election Commission of India take action against these two political parties which have violated FCRA by receiving donations from a foreign entity which you are not eligible to. Then what happened? Guess what might have happened? Both these political parties colluded with each other, collaborated with each other, and this law was amended. First in 2016, then in 2018. Basically what the parliament said, because these political parties came together, the parliament amended FCRA and said, if you have a company, a foreign company, but this foreign company has subsidiary in India, then you can receive foreign donation from these subsidiaries of a foreign company. There is something called FDI limit. What is this FDI limit? There are some entities, there are some areas where 50% FDI is allowed. For example, if this subsidiary of a foreign company is within this FDI limit, then this foreign entity does not become foreign entity, it becomes an Indian entity. And an Indian entity can donate money to political parties. It is not violation of Foreign Contribution Regulation Act. Long story short, can a political party receive foreign contribution, foreign donation? No. But two political parties, BJP and the Congress, were allegedly receiving foreign contribution from a London-based entity. Then both the political parties got together, amended this law, and ultimately the amended law says, even if it's a foreign company, but it has subsidiaries in India within the FDI limit, that means if 50% is controlled by the foreign company also, but since it is within the FDI limit, this is not a foreign company, it can donate money to political parties. And do you know how it happened? In 2016, 2018, money bill route was used to amend this law. Money bill route was used to amend this law. And you would know that when a money bill is introduced in the Lok Sabha, Rajya Sabha has a very limited role to play. Rajya Sabha cannot reject a money bill. So as to ensure that this bill is passed quickly, money bill route was taken. But one more interesting thing. Normally laws have a prospective effect. That means this law was enacted in 2016 or 2018 later. This would have come into effect after 2016, after 2018. then what would happen to the contributions which were already made to these two political parties before 2016, before 2018? The parliament amended this law retrospectively, saying this law, this amendment will enter into force from a previous date. Which previous date? 1976, when the law was first enacted. That's how these two political parties colluded with each other, amended this law to ensure that they are not penalized by the courts for violating FCRA. But be that as it may, according to the government, there are NGOs, various organizations which are able to receive foreign contribution. And such contributions are divided into 5 broad heads. There may be some cultural NGOs, some economic, educational, social and religious purposes. That means for social purpose, religious purpose, educational purpose, economic purpose, cultural purpose, we are providing you foreign contribution. We are donating money to these organizations. According to the government, there are 16,000 such organizations which are registered under FCRA. And cumulatively, these organizations have received 22,000 crore annually as foreign contribution. And a part of this money can also be used to destabilize the elected governments, to fuel protests against the nuclear power plants, aimed at religiously converting people. And as such, we need a tougher law. A more stringent regulatory regime is required. But why is this bill viewed as controversial? What is the major change that is to be brought about because of these amendments, if these amendments are passed? Now listen to me carefully. For example, this is a non-governmental organization. It has received foreign contribution. And through this foreign contribution, it has established hospitals, educational institutions, or religious institutions, for example. Now there is an allegation against this organization, against this NGO, that you have diverted funds, that you have spent more than 20% for administrative purposes. For example, you are using these funds for religious conversion. This NGO will lose its registration. But then what will happen to the organizations already established by this NGO? For example, these hospitals, educational institutions, religious institutions. For that, this amendment says that the central government will form a designated authority. And then this designated authority will take over all these assets and run them, manage them. Which basically means that companies or organizations already in place which have received foreign contribution, and they have already established religious institutions, charitable institutions, educational institutions, or hospitals. Now a designated authority created by the central government will take over these entities, which some people argue that it is basically targeting the Christian missionaries and their hospitals, their educational institutions, their religious institutions, so that we will not approve their license registration. That means you have a license which is up for renewal, but you did not apply for renewal, we will take over these organizations. You applied for renewal, but we denied it because of various reasons, we will take over these institutions. You have 6 months. Within the 6 months of the expiry of your license, you have to apply for renewal. If you did not obtain renewal before the expiry, we will take over these institutions. This is where the critics argue that there is a link between the Waqf Amendment Act of 2025 and these FCRA amendments of 2026. Now, this is what the critics say. These are not my words, but listen to me. Critics say that through Waqf Amendment, you try to take over the properties or the institutions of the Muslim community. For example, Waqf, a property donated by Muslims to their God. If the central government feels that this is not the Waqf property, there is a dispute on this property and this property cannot be used as Waqf. For anyone to donate to Waqf, you should have been a practicing Muslim for 5 years. Although some of these provisions were stayed by the Supreme Court. But be that as it may, the allegation is that you used Waqf Amendment Act of 2025 to basically target the Muslim properties. And now you're using FCRA Amendment of 2026 to target the Christian missionary organizations. For example, their hospitals, their educational institutions, their religious institutions. Whether there is a link, there is no link, this is what the critics say. These are not my words. But then the point is, why are these amendments considered to be dangerous or arbitrary? For example, here is this NGO which has established a hospital. And this hospital was established primarily due to the foreign contributions received by this NGO. I am the central government. I want to take over this hospital. How can I take it? NGO will apply for renewal. I will deny renewal. When I deny renewal, I will take over this hospital. This seems unfair both in principle as well as procedure. Which means if the central government wants to take over a particular institution, all the central government has to do is to deny renewal of the license of this NGO. Which means once I deny you the license, I will take over this organization. How many FCRA licenses have the government cancelled? How many were applying for renewals, but these renewals were not granted? How many renewals were disallowed? These questions were asked by opposition politician John Brittas in the parliament. But he says that since 2024, none of these questions have been allowed, which means I don't have an answer to all these questions. The Hindu newspaper, for example, it says that there can be a reasonable assumption that the government allows only some to receive foreign funds. So there is an element of favoritism ingrained into these policies. Whoever we allow, they can receive foreign contribution. Whoever we will not allow, they cannot receive foreign contribution. This seems violation of the principles of the natural justice. This is what FCRA is. Primarily meant to be a law which can regulate foreign contribution in India, but over a period of time, critics argue that this law has been weaponized by the central government. Through its favoritism, it is allowing some to receive foreign contribution and not allowing others to receive foreign contribution. But then those who defend these amendments, defend this law, they say that this is required for national security. Because you cannot allow foreign contribution to destabilize elected governments in India. What if there is an NGO which is receiving foreign donation primarily for health or education or cultural reasons, but is misspending that money and fueling protests against the government established by law, or fueling protests against the nuclear power plants, or fueling protests against the laws enacted by the parliament, for example, the Citizenship Amendment Act, for example, a proposed scheme or a proposed policy called the National Register of Citizens. So on one hand, there is a national security angle. On the other hand, there is a fundamental right of an individual to establish organizations of their choice. What do you think of these amendments? Do let me know in the comment section. And thank you for watching.